This morning, we are interviewing Denver area patent attorney Mark Trenner. Mark has been practicing as a patent attorney in Colorado for almost 14 years, the past 9 years at Trenner Law Firm. While his practice focuses primarily on helping small businesses protect their inventions with patents, the Trenner Law Firm also assists clients to build out all aspects of their intellectual property portfolio, including copyrights, trademarks, and trade secrets. Now, Mark, the National Law Review recently published an article that appeared in the Orange County Business Journal titled Trade Secret or Patent. The choice is not always simple. Please start by explaining the difference between a trade secret and a patent.
Sure, I can do that. A trade secret is anything that can be maintained as a secret. It seems self-obvious. If it can be reverse engineered, then it can't be protected as a trade secret. So, for example, a recipe might be protected as a trade secret. Think of the Bush's Baked Beans commercial.
Where the dog wants to give away the family recipe?
Right, and the owner always stops the dog just in time. That's because if the recipe were to be broadcast on national television, it would be considered to be in the public domain and no longer subject to trade secret protection.
Okay, so what about patents?
Well, patent protection is afforded by the government for inventions for a given time period. That's typically 14 years for a design patent and 20 years from the filing date for utility patents. But this protection is granted in exchange for what is sometimes called a limited monopoly. That is, the patent owner has the exclusive right to make, use, and sell their invention, at least in the United States, during the term of the patent. And in exchange, the government requires that the patentee, or the person applying for the patent, disclose every aspect of their invention.
I see. So a patent is kind of the opposite of a trade secret.
In a way, right. Because the inventor is required to disclose the invention in sufficient detail that someone having ordinary skill in the art can practice the invention.
So based on the difference between patents and trade secrets, the choice seems self-evident.
You mean that you can only apply for a patent for something you can't trade secret, and you can only trade secret something that you can't patent, but not necessarily.
Which is why the article says the choice is not always simple, right?
That's right. The article supports what you just said, that in some cases, that not every type of information can be protected by a patent or trade secret or both, but as the article correctly explains, sometimes information may be capable of being protected by both trade secret and patent, but not both at the same time, or at least not the same information both at the same time.
How so?
Well, the article explains that it may be wise to publish the relevant information, and publication should also prevent others from applying for patent protection for the same invention.
And what about trade secret?
Well, the article offers a good strategy here, where the applicant for a patent files for a non-publication request so that the patent office doesn't publish the patent. So during this time, the information can be maintained as a trade secret. If the patent does not issue or the applicant wishes to maintain the information as trade secret, the patent application can always be abandoned before it issues, and therefore it's never publicly disclosed, hence maintaining your trade secret. But when a patent does issue, it's protected by the patent, although no longer as a trade secret.
Gotcha. So you're not required to publish your patent application.
Generally, the Patent Office will publish your application after 18 months from the filing date. But for those first 18 months, you're right, the patent application is maintained in confidence by the Patent Office, and it can't be accessed by the public. In addition, an applicant can file a request for non-publication, in which case the Patent Office is going to not publish the patent application unless and until a patent actually is allowed to issue. But an applicant can't file a request for non-publication if the patent application is being filed outside of the United States. Then the application has to be filed.
I see, but that's kind of confusing.
It is, and the article correctly explains that these are very important business decisions that should be discussed with a qualified patent attorney to determine what's best in a given particular situation.
Gotcha. Well, Mark, sounds like that's all we have time for today. You got a call coming in there. So for more information, make sure you visit Trenner Law Firm's website